Welcome to Show Don't Tell. The free trade TTIP argument has died down recently, though thanks to Brexit it'll inevitably flare up again. So in this, the first of two videos, we're moving ahead of the game, with Show Don't Tell on the frequent claims made about TTIP and free trade disputes. Today's video will address Investor-State Dispute Settlement, or ISDS, the private arbitration invoked under bilateral investment treaties and multilateral treaties such as NAFTA. Arbitration allows foreign investors to sue a country outside of domestic courts. Companies can't just move quarries and seaports somewhere else, so they want protection against politically motivated courts, retroactive law changes, and expropriation. For their part, countries dislike giving jurisdiction to outside legal bodies like the US and the International Criminal Court. The result, there's no established international court to settle these disputes, so the compromise solution is an ad hoc court judged by a mutually appointed panel of 3 arbitrators. It's expensive and slow compared to most developed country legal systems, but the option of arbitration is often part of these treaties. The system is controversial. On the one hand, governments become subject to judgments of a private court. On the other hand, arbitration facilitates access to justice and upholds the rule of law. In this video, we're going to address the specific claims raised about Interstate Dispute Settlement, ISDS, particularly those raised around the TTIP dispute. This video will focus entirely on ISDS. I will address hormonal beef in the future, so do please try and keep any TTIP whataboutery to a minimum. Your patience is appreciated at this time. As I've said before, whichever side you take on an issue, do it for reasons that are true. Find the facts, be Galileo, not Aristotle. International arbitration wasn't invented recently. There's a sizable body of precedent out there that I'm going to read through and share with all of you. Hopefully you'll find this educational and interesting. This is Show Don't Tell, so let's get into it. Let's begin with the first claim. TTIP disputes would be heard in secret courts. Fortunately, Greenpeace leaked the draft of the TTIP agreement, including the section that deals with dispute resolution, so let's get reading. Here we are, browsing through. The document lays out the structure and agreement behind arbitration, but soon we come to the section about how the arbitration process works and its rules, including the section where it says, all submissions will be made public, all responses will be made public, and that all hearings, of which there will be at least one, will be open to the public. The section isn't written in technical language. It's clear to anyone who knows how to read and examine the document. Hearings and evidence will be public under TTIP. This text seems to have been agreed between both sides already. Of all the things that I found after all the protests I saw, this stunned me the most. Greenpeace's leaked documents are clear about the facts. Yet protesters never realised their own leak contradicts their own claims. Absolutely incredible. So let's move on to the next claim. The ISDS tribunals restrict the ability of governments to pass regulation or create regulatory chill. Here are 3 precedents to address this particular claim. Case 1. Chemtura vs Canada from 2010. Chemtura made a pesticide called lindane which the Canadian government decided to ban. Chemtura appealed under NAFTA. The result? A win for Canada. And as this is Show Don't Tell, I'll read a key paragraph from the judgment. The PMRA took measures within its mandate in a non-discriminatory manner motivated by the increasing awareness of the dangers presented by lindane for human health and the environment. A measure adopted under such circumstances is a valid exercise of the state's police powers and as a result does not constitute an expropriation. Case 2. Methanex vs United States from 2005. The state of California decided to remove methanol additives from its fuel. Methanex sued and the result? A win for the United States. Again, I'll read a key paragraph from the judgment. Faced with widespread and potentially serious MTBE contamination of its water resources, California ordered a careful assessment of the problem and thereafter responded reasonably to independent findings that large volumes of the state's ground and surface water had been polluted by MTBE and that preventative measures were called for. But before boredom and regret drive you to press the back button, here's a case that went the other way. Case 3, Bilcon versus Canada from 2015. Bilcon was an American company who wanted to build a quarry and port in Nova Scotia. However, they failed the environmental impact assessment and they sued under NAFTA. The result, a win for Bilcon, one of the few examples where a developed country lost at an arbitration. Now things are getting interesting. You can sue because you failed an environmental impact assessment. However, on reading the judgment, the reality is very different. The entire assessment was a farce. Amongst many failings, the panel didn't bother questioning Bilcon's experts or retaining their own, and so made erroneous conclusions, claimed there remained unanswered questions, and rejected permission on a non-environmental basis. As alleged by Bilcon, the hearing lacked any significant consideration of the science and turned into a soap opera for activist groups opposed to the quarry. Or, as the judgment put it, in the present case, the tribunal is unable to discern any justification for the differential and adverse treatment accorded to Bilcon that would satisfy the Pope and Talbot test with respect to the standard of evaluation under the laws of federal Canada. The community core values approach adopted by the JRP was not a rational government policy, it was at odds with the law and policy of the CEAA. In short, Canada lost because the actions of their panel broke the law. But what makes it more interesting for our purposes is where the arbitrators explicitly address the worry that arbitration can impair regulation. I apologise for the length of this reading, but you knew this was show don't tell and it's very significant. The judgment went on to say, a NAFTA tribunal must be sensitive to the need to avoid regulatory chill, including with respect to protection of the environment. It may bear reiterating, therefore, the tribunal's view that under NAFTA, lawmakers in Canada and the other NAFTA parties can set environmental standards as demanding and broad as they wish, and can vest in various administrative bodies whatever mandates they wish. Errors, even substantial errors, in applying national laws do not generally, let alone automatically, rise to the level of international responsibility vis-à-vis foreign investors. The trigger for international responsibility in this particular case was the very specific set of facts that were presented, tested, and established through an extensive litigation process. So do ISDS hearings restrict the government's ability to impose regulations? I have to say, false. All my precedents show if you act in the public interest using evidence, rather than trying to punish a particular company, there's nothing for a tribunal to point at and say, that's not allowed. So let's move on to the next question. Under ISDS, can you sue for loss of future profit? Well, there are two answers to this question. First of all, loss of future profit is no reason in itself to ask for compensation. But if the arbitrators find in favour of the investor for a valid reason, can you be compensated for lost future profit? Well, the simple answer is yes. The rationale is that if you've had your assets taken from you, you're entitled to receive fair market value, which is often calculated with reference to future profits, and we'll show an example shortly. Fair market value claims are more straightforward in the case of an asset seizure rather than speculative what-if profits. What will be very interesting is the judgment for damages in the Bilcon versus Canada claim, the assessment of which is still ongoing. Bilcon wants $400 million in compensation despite not building anything, so it'll be very interesting to see the verdict on this. But let's pause a moment to ask the question, what do you need to show in order to get compensation? Well, the phrase that comes up most frequently in these judgments is legitimate expectation. I've seen other non-arbitral instances. For example, in the year 2000, a firm called Ian Edgar Liverpool sued the United Kingdom in the European Court of Human Rights for compensation after the UK imposed a ban on handgun sales. He lost, and the court said, the applicant company has at all times had to operate within a framework of control of the trade in firearms, which has existed in the United Kingdom since 1920 and which has become progressively more restrictive. In these circumstances, the court agrees with the government that the applicant company had no legitimate expectation that it would be able to continue to trade in any particular type of firearm, including handguns. So first of all, you need to show legitimate expectation. Legitimate expectation can be procedural, that is, you had a right to be consulted, or substantive, that is, you had received a firm commitment. But how far do you have to go in order to break legitimate expectations? Well, the whole doctrine is laid out very nicely in the case of Bhatt Murphy versus the UK government, a case about reducing fees paid to law firms who sought compensation from miscarriages of justice. In the words of Lord Justice Laws, after laying out the requirements to meet legitimate expectations, he said to do otherwise in any of these instances would be to act so unfairly as to perpetrate an abuse of power. An abuse of power, and this is what all three cases I mentioned were really argued on. Not that regulations were wrong, but that the government had abused its power and discriminated against individual companies in doing so. And in Bilcon's case, they were able to prove such an abuse had occurred. Now let's talk about the final claim, that panels can give huge awards to companies paid by small and impoverished nations. Case in point, Occidental versus Ecuador. Following a period of political instability, Ecuador seized the oil rights and assets of Occidental Petroleum, claiming that Occidental sold a minority stake in their rights without approval from the government. Occidental countered this was debatable and that seizure was disproportionate. The result, a win for Occidental. The Republic of Ecuador ordered to pay $1.8 billion in compensation, an award later reduced to $1.1 billion. It was reported what a huge burden this was for a small and impoverished country. Articles unfavourably compared the amount to Ecuador's healthcare or education budget. However, these articles gloss over a simple fact posed through a simple question. Why $1.8 billion? Why this particular huge amount of money? Experts on both sides assessed the lost future profits that resulted from the seizure to determine fair market value and came to the number of $2.4 billion. So to be clear, Ecuador now owns $2.4 billion of oil production rights, for which they paid just $1.1 billion. Ecuador retains these seized oil rights. They can use the income from oil production to pay for healthcare and education. They actually made a sizable profit. $1.8 billion is not a punishment for Ecuador, it's the cost of paying for what they now own. It's hardly the impoverishing outcome that people concluded was a result of the tribunal. And finally, with the passage of time, it seems that most of the claims listed by advocates at the time of TTIP have actually been found in favour of the governments being challenged: Pacific Rim versus El Salvador, Veolia versus Egypt, and Philip Morris versus Australia, to name just a few. It turns out there is a big difference between having the right to sue and actually winning your case. This all really brought home to me how much fear and lack of knowledge create demons and bogeymen for people. TTIP itself explicitly avoided private courts, regulations are protected, and arbitrators apply standards of legitimate expectation to protect against abuses of power and compensate based on fair market value lost. The only real argument against ISDS I can see is the Brexit argument that a nation should be sovereign and shouldn't have its actions interfered or challenged by outsiders, even in a case of abuse of power. Anyway, that's all for today. Congratulations on reaching the end of this rather long video, and I'll see you next time.